May it please, my lord. Your lordship.
You're going to address this first. You are the amicus.
My lord, I would request your lordships may hear me first, because there are two judgments before my lords, my lord.
Yes.
I will, my lord, I've had a lot of thought about this. I've also talked to the appellant also, my lord. I may not agree, my lord, with some part of one judgment and some part of the other judgment also. So, my lord, let me put out the case. Some portions they may not have to respond at all. At least your lordships will get the full picture. I request, if your lordships permit, let me, my lord, lay it out, and then your lordships may decide that way. It will be.
I'm for the respondent number one, my lord. After the amicus.
You're for respondent number one.
After the amicus completes, my lord.
That is, you filed a Section 8 application.
Yes. Yes.
It has been allowed by the High Court.
Right,
Yes.
right.
In the petition.
Right.
Yes.
Correct?
Yes. My lord, the matter arises out of a reference in the NN Global case.
Correct.
One paragraph of which is relevant, my lord. I'll read it out. My lord, but this matter has a little wider implication, because the issue which is now arising before, my lord, this honorable court and various high courts is really mainly in the Section 11 jurisdiction. Because what is happening, my lord, is that there are two opposing views. One view says that if somebody points out to you that a document or an instrument is insufficiently stamped or not at all stamped, you, the Section 11 judge, have no choice but to impound and proceed. That's one view, my lord. I would say that's the Garwade view. The other view which has been propounded is that no, this may not be. So, my lord, this is one possibility. One possibility which, and this is the possibility, this is what is being done now by the Bombay High Court. They are following this. My lord, the Delhi High Court, on the other hand, is appointing arbitrators and leaving this question.
Section 16.
In Section 16. Two judgments of this honorable court, my lord, have appointed arbitrators pending this reference. There are other cases which are pending where the judges have adjourned the matter to await the reference.
Oh.
So, my lord, this is if I may say so, there's a khichdi, everybody is going their own way. So it is ultimately for your lordships, my lord, to lay down the law one way or the other, whichever, my lord, appeals ultimately to your lord. Now, my lord, that's the practical aspect of the matter, my lord. My lord, also, my lord, I have in this regard, we have filed 4 volumes of compilation for your lordship's kind consideration. Essentially, my lord, the first volume is of the reference judgments. There are 3 judgments which are referred to your to this court, my lord. One is Garwade, one is, my lord, NN Global, and because intervening between the two, there is Vidya Drolia, and certain paragraphs of Vidya Drolia have been done.
46, 47.
Yes, those 3 judgments are from the first volume. My lord, the second volume which we have filed is in re the Stamp Act, because your lordships will find that in all these judgments, the focus, my lord, because, sorry to say this, my lord, arbitration appears to be very glamorous. The focus appears only on the Arbitration Act and not much debate or not much disputation insofar as the Stamp Act is concerned. So, my lord, the Stamp Act I will place before the Arbitration Act to understand, my lord, whatever my limited understanding of the Stamp Act. Then, my lord, one volume is on the Arbitration Act and one volume is on the 2 reports of the one of the Law Commission, of the 246 Law Commission, and one high-level committee, Justice Sri Krishna, and 7 or 8 articles, my lord, which I have put in only to show that people have very disparate views and use very sometimes intemperate language also. But, my lord, there are points of view in those articles which go one way or the other. So, my lord, I have also tendered for your lordship's consideration just now, my lord, a note of submission. It's rather detailed. I'm sorry that it's so detailed. It's 40 pages because I have actually referred to paragraphs which are, my lord, to be considered and some quotations. It is only to obviate my lord, the necessity for lot of note taking. I have tried to, my lord, therefore it's a little long. So, my lord, the way the note is organized is this. It's really, my lord, in 4 parts. My lord, the first is what is the scope of the reference and what is the submission I will make for your lordship's consideration. That's a couple of pages. Then, my lord, the Stamp Act, then the Arbitration Act, and only then, my lord, the reference judgments. Because I don't want your lordships to be colored either way by the reference judgments. There are some problems, my lord, in both of them, at least so far as I see. I may be wrong. So, my lord, that is the way I want to proceed, and of course, my lord, subject to whatever your lordships. So, my lord, the reference, there are 3 paragraphs in the reference order. If your lordship just sees the note, and please pick up, my lord, the reference volume. I've my lord, tendered one volume of the, you have the volume 1, reference judgment.
Convenience volume 1.
Convenience 1. My lord, there are 3 paragraphs of NN Global which crystallize this particular reference. I'll show those 3 paragraphs. If your lordships first come to page 194, which is where NN Global starts, my lord.
Mr. Banerjee,
Yes.
one question. See, an arbitration agreement is really an agreement within an agreement.
Right, my lord.
So effectively, there are 2 agreements.
Right.
So for the stamping purpose, what would be the valuation of the arbitration agreement? Just
My lord, I can answer that, my lord. For the stamping purpose, my lord, it is not the agreement which is relevant, but it is the
Right.
instrument.
instrument.
It's
yes.
the instrument. Now, my lord, an instrument may have more than one agreement. As
The
your lord.
line of cases are there that there are actually 2 agreements so far as
Yes, my lord.
arbitration is concerned.
Yes.
One is the main agreement
And one is the arbitration agreement.
arbitration
No
agreement.
difficulty.
What would be the value? How does
How the value is fixed, my lord, under the Stamp Act, my lord, if there is such a situation where in one particular instrument, my lord, more than one agreement is there, or more than one subject matter is there, my lord, section 5 and 6 of the Stamp Act deal with that situation, and it is really the higher value, the value of the substantive agreement, which is taken as the value of the instrument. You know, there are methods in the Stamp Act, I will show you also, which resolve it. So, my lord, Stamp Act issue is slightly different and Arbitration Act issue is slightly different. And if we keep them separate, my lord, then of course, my lord, we can match them up. Because the valuation issue, my lord, can be seen really with the Stamp Act. And unfortunately, there seems to be an error in NN Global, my lord, on the Stamp Act, which I will also, my lord, highlight. So that
Will a document which is unstamped, will it be correct to describe it as unenforceable? Or will it be more correct to say that it is inadmissible in evidence?
My lord, I would go with the second and I will place those judgments, my lord. I will show that an unstamped document is a valid document. My lord, it is merely inadmissible in evidence. The underlying transaction is valid and my lord, it is not null and void. That seems to be the problem with the judgment in Garware. My lord, I will highlight that in the first court. So it is valid, but it cannot be, my lord, admitted in evidence. And
You are actually saying that